We have our course outline. I'm Barrister Mrs. Musa Memunat, lecturer at Federal Polytechnic, Auchi, Edo State. The course is General Principles of Law in Nigeria. And we have the course outline here. The first one is Definition and Introduction of Law. 2 is Different School of Law. 3 is Classification of Law. And 4 is Importance of Law. 5, Sources of Nigeria Law. Then 6, the Judicial System. 7, Nigeria Court System. 8, Rules of Interpretation of Statutes. 9, Law of Tort. And 10, Rudiments of Constitutional Law. First of all, we'll start with the definition of law. As it is, there is no universal and accepted definition as to what law is. And in trying to define law, there has been serious problem, really serious problem in giving the definition of law. And in that, different schools of law came together to give their own definition as to what law is. When I say there's no universal and accepted definition of law, it's like bringing an elephant to the market square and inviting 3 blind men to come and feed the elephant to state what they feel in respect of that. And at the end of the day, these 3 blind men are going to give different feelings as to what they felt in touching that elephant. The first one may say that, oh, this elephant is like a fan, you know. Second one may say, it's like a, you know, a bench. And the other one will say, it's like a refrigerator. That is how law is. And there has been serious problems in defining law. So first of all, we all have our own definition as to what law is. So we can give our own definition and give a definition. At the end of the day, there's no best definition as to what law is. So we can say that law is rules and regulation guiding us in different society, which we obey. At the end of the day, when there's disobedience, there are sanctions to be apportioned in respect of those that disobey that law, because law and rules are meant to be obeyed. They are not meant for the fun of it. So when there are no sanctions, nobody will ever obey the law. So first of all, we have the School of Law, which is the Naturalist School of Law, which came together to give their own definition. That school of law is deep-rooted in religion. We have the people like Marcus Tullius Cicero. We have Aristotle. We have Thomas Aquinas. We have Hugo Grotius. We have John Locke. They came together to give their own definition as to what law is. And that school of law is the most popular school of law in history. So they are men of God, and the school of law is deep-rooted in religion. They say that law is something that is good, just, fair, and moral, that will be able to command the obedience of the general people or the majority of people in the society. That is how they see law. In all the definition, there are criticism. So the criticism under this law is that the main criticism of the natural school of law is that when rules could present only the notion of good and bad behavior in society, they become rules of morality and not rules of law. And while the utilitarian school of law, they talks about the utility, that law should be something that we give a utility to the majority people of the society, that will give them a greater happiness to the people in the society, their liberty, their security, equality. So they contend that government in enacting law to attain or achieve this utility should weigh the interests of the individual against that of the majority, and prefer the interest of the majority against that of the individual. In other words, the state should seek and promote the greatest good for the greatest number of the people in the society. You know the criticism. So this criticism is that the criticism of utilitarian school stems from the fact that there are quite a number of laws which are exploitative, oppressive, and vindictive, especially under dictatorial rule, rather than serving any utilitarian purposes. Then we also have the positive school of law. The major author of that school of law is John Austin. And acts. So they see law like a command from the political superior, which is the sovereign, the people in government, to political inferior, the people that they led and sanction. So they see law as a command. So anything that will come from the superior is a command to the inferior person. So that is how they see law. And under this school of law, we still have Thomas Hobbes, who defined law as an obligatory rule of conduct or the commands of him that have coercive power. So under this criticism is that it's not every command from the political superior that is that can affect the minority or the poor people in the society. Then we have the historical school of law. The founder of that school of law is Friedrich von Savigny. He was a German lawyer. So he believed in evolutionary, that law is evolutionary. So they contend that every community is bound together as one people by a spirit of the people, or Volgist, so which make them distinct from others. They contend that further that for the law to be valid in a given society, it must take into consideration the historical antecedents and way of life of the people, and should be allowed to develop over time from the history and way of life of people. So under this school of law, they believe in the olden days happenings. Like, for example, they believe in the killing of the twins and killing of Albino. So those are what those people believe in. Olden days happening, the way we dress those days, that we put on a sack and all that. That is what they believe in. They believe in the olden days happenings. They have the sociological school of law. The founder of that school of law is Auguste Comte. He was a French philosopher, which associated with the origin of sociology, as we know it today, because he was the first to employ the word to connote the study of society as an independent discipline. His work rose to prominence from the mid-19th century into the 20th century. So the sociological jurisprudence marked the beginning of Western study of law outside the positive boundary. He tends to be skeptical of the rules presented in textbook and is concerned with what is actually happening in society. That is to say, the law in action. So it's like the opposite of the historical school of law, which believe in the olden days happening. So they believe in the social activities that regulate the society. So they believe that anything that is happening in society presently should be the law that will regulate the people in that various society. They have the realist school of law. The founder of that school of law is Oliver Wendell Holmes. He was a US Supreme Court. So he defined law as the prophecy of what the court will do, or nothing more pretentious, which is what we are seeing today. So which line means that the law is the opinion of the court. Even when the sovereign, the sovereign make laws, so that law is still going to be subject to the interpretation of the court. The lawmakers will make law. At the end of the day, they will bring that interpretation to the court. It is what the court say that the law is. That is law, nothing more pretentious. So they believe what anything that the court say, irrespective of whoever that makes the law. Then we have criticism under this school of law, which argue that the realist perception of law is too restrictive as a result of the fact that other law exists apart from the case law or judicial precedent. That is to say, they criticize it to say that apart from what the judge interprets, other law do exist. Then we have the Magic School of Law. The author of that school of law is Karl Marx. He was a German philosopher and a jurist, which believed that it is the particular level of social development that determines the nature and content of law. So they believe that, unlike the historical school of law, they do not believe that law evolves at the same time. With the evolution of human society, rather, they believe that law and state emerge where and when the society was divided into class. So when exploiters and exploited emerge, and the emergence of private property too. So unlike the, as against Austin command theory of law, they contend that the legal superstructure ensure class domination, not the domination by the sovereign. So this Magic School of Law, they believe that anything that the political superior would do, or the people in government to oppress the poor, that is what they see to be law. Say they see law as an instrument of oppression and exploitation by the political superior, those people in government against the political inferior. That comes to the end of the different school of law. So at the end of the day, you see that law has no universal and accepted definition. Even when the school of law came together to give their own definition, no one was the best and no one was the most accepted one. It's like as we all have our own definition of law. We have classification of law. Law can be classified into various categories. We have the criminal law, the civil law, the private law, we have public law, we have substantive law, procedural law, we have municipal law, and international public law. When we say criminal law, it is the law of crime that deals with crime. So criminal law deals with public individual, especially the government and private individual. So it is the law of crime, as the name implies, criminal law. So that criminal law, we have the government that prosecute under the criminal law, the police, which are the government agency that prosecute on behalf of the government. We have the state council, we have the prosecutors and all that. So any crime that is happened or that is happening in the society, or any crime that occurred in the society, it is government that will take care of that. At the end of the day, when somebody is being murdered, it is the government that will represent the person in court. That is why we have the state council. They represent the government and against the person that committed the offense, which is the defendant. So example of crime should include arson, we have assault, banditry, we have burglary, childhood abuse, money rituals, rape, robbery, sedition, sexual harassment, terrorism, and treason. So the police and the state council, they represent the police and the state council represent the government against any individual that committed an offense. Then we have the civil law. The civil law is the old private law, except a criminal law. We have different branches of civil law. We have law of contract, we have law of tort, we have family law, we have property law, there's law of succession. And the difference between civil and criminal law is that civil law deals with private individuals, while the criminal law is the law that deals with the government and private individual. It's like private law is like a civil law too. Then while public law is like criminal law. We have a procedural law and substantive law. Substantive law is the law as in the substance of the law itself, as it's contained in the law book. For example, the body of rules of law itself as contained in the law book, e.g., rape, murder, burglary, forgery, assault. So there are offenses contained in the criminal code, while negligence, defamation, trespass, etc. are taught as common law. Right to life, we have right to liberty, right to freedom of movement, right to freedom of expression, etc. are constitutional rights. We have procedural law. Procedural law is the laid down rules governing the manner in which a right is enforced under civil law or a crime is prosecuted under the criminal law. That is to say, procedural law is the law that governs the step to be taken in applying on enforcing the provisions of a substantive law. You have a municipal or local law. As the name implies, municipal law is the law governing a country, governing a state, as in Nigeria as a state, the law governing interstate relationship, as Nigeria, for example, like Lagos and Edo State, Zamfara, and Ondo State. So when you say municipal or local law, the name implies it is the law that governs interstate relationship. Then we have international law. International law governs inter-country relationship. For example, let's use Bakassi case as an example. During the Bakassi land, the Cameroon, where the matter went to international court between Nigeria and Cameroon to ascertain who owns the land between Nigeria and Cameroon. So at the end of the day, the land was awarded to Cameroon, the Bakassi land. And that was an example of public international law, because the matters fought under inter-country relationship. Then we have importance of law. What is the importance of law? The importance of law is that law maintains order in society. That is to say, without law, there will be chaos and anarchy in our society. The law helps to in our society. The law prevent us from acting our natural desire to extract retaliation in revenge for actual or perceived wrongs. Law helps to resolve dispute over sharing of our limited natural resources. The law defends us from those who would seek to harm us for no good reason. We have several importance of law. Then we have a sources of law. When we say sources of law is the source where we derive our laws from. The term Nigerian law is used to refer to the totality of laws that are enforced in the various places in Nigeria, and those laws that might have been repealed in the course of history. Although the term sources of law or source of law can be used in different sense, here reference is being made to the fountain of the law that have at one time or the other been enforced in Nigeria. It also includes the law that are currently enforced in Nigeria. Nigerian law came into existence through various ways and at different times. So the main sources of Nigerian law includes the received English law. We have the Nigerian legislation, customary law, judicial precedent, and international obligation. We also have opinion of test writers or legal research. When we say received English law, they are the laws that form the bedrock of Nigeria as a result of the fact that before Nigeria attained political independence in 1960, it was an English colony and ruled by the British government. The Queen of England, as at that time, was the ceremonial head of Nigeria and other protectorate country. So the Queen of England was the one that could make laws for Nigeria to follow, and she was also the ceremonial head of Nigeria. So the received English law was introduced into Nigeria first in the colony of Lagos in 1863, following the enactment of Ordinance of Number 3 of 1863, which effective 4th March, which took effect from 4th March 1863. So the English law consists of the common law. We have the Doctrine of Equity, Statute of General Application, which came into force in England on 1st January 1900. We have the statute and subsidiary legislation on specified matters. We have the English law made before October 1st, 1916 and extended to Nigeria. You know, before now, the Queen of England was the one making laws for us to follow. But when Nigeria gained our independence in 1960, the Queen of England stopped being the head of Nigeria, but was still making laws for Nigeria to follow. But when Nigeria became a federal republic in 1963, the Queen of England not just stopped being the head of Nigeria, he also stopped being the one making laws for Nigeria to follow. So the ties between Nigeria were broken entirely. At that time, all ties between Nigeria and England were broken. Then we have the common law. The common law was this law that was very rigid, strict. Then under the common law, it was possible for litigants to suffer a wrong to be without a remedy. And under the common law, it was even impossible for litigants to get a writ to file their cases. So the common law was founded by England's forefather. So it has been described as the body of those principles and rules of action relating to the government and security of persons and property, which derive their authority solely from usages and customs of immemorial antiquity. So that is to say, common law was founded by the English forefather. Out of their common sense, they made common law, although it was very strict and rigid. Then under the common law, judges were traveling from one place to another to dispense justice according to the prevailing customs of the people that reside in that various community. So then the judges were known as traveling judges. That is to say, itinerant judges, meaning traveling judges. They travel from one community to another to dispense justice according to the customs of the people. So they were traveling from one place to dispense justice according to the prevailing customs of the people. They didn't have courts in a fixed place to dispense justice, and there was no place. They can just travel to a community and sit under the tree and dispense justice according to the customs of those people in the community. So they were called the itinerant judges, meaning traveling judges. And common law was unwritten. It was unwritten. It wasn't written anywhere. So because of that, it was very rich, strict, and people suffer under the common law. They couldn't get a writ, and even when they win a case, there will be no compensation. That is to say, under the common law, litigators suffered a wrong to be without a remedy. When they win a case in the court, there will be no compensation under the common law. So common law was that rigid. So under the common law, judges were traveling. But when the Magna Carta Act of 1250 came, required that there should be a court in a fixed place, common law courts were created. The first one is the King's Bench, which the Queen of England or the King of England was the head of that court. And that court was dealing with criminal cases. The second one was Court of Common Pleas, which is the one that deals with civil cases. Then the third one was Court of Exchequer, which deals with revenue cases. All the revenue cases in England goes to that court then. So they now created the three courts. And by then, the judges were not traveling again. So they now have a fixed place to dispense justice according to the prevailing customs of the people under common law. So the problem with common law, as I earlier said, was that the common law was very strict. It was possible for a person to suffer a wrong to be without a remedy. And under the common law, it was possible for a litigant not to get a writ at all to fight case in the first place. And for the reason that common law is based on judicial precedent, which means stand by your decision, it became very rigid and difficult to amend. And where there was no precedent on which the court could rely on, the litigant was left without a remedy. The common law remedies were limited to award of damages, repudiation, that is to say, withdrawal from or cancellation of agreement by the aggrieved party, and the party reverted back to the position they were before the agreement was entered. Then we have doctrine of equity. The equity means fairness, justice. In law, it refers to that part of English law originally administered by the Lord Chancellor, and later by the Court of Chancery, as detailed from that administered by the Court of Common Law. Then equity came, the origin of common equity is that equity came not to replace common law. The equity came to ameliorate, reduce, mitigate the harshness of common law. Where injustice was being done to people without remedy, that is what equity came to relieve. So people were not satisfied with the common law system of justice, petition of the king and the fountain of justice. So because of that, common law came to ameliorate that injustice that was being done to the people under common law. So under the equity, we have a lot of remedies, because equity is fairness, is justice. We have a masses of equity. Under that masses is that delay defeats equity. Equity is equality, and equity act in persona. So equity act on conscience, and who comes to equity must come with clean hands. So equity follows the law, and equity aid the vigilance. Equity will not assist a volunteer. Equity will not permit a statute to be a cloak for fraud. He who comes to equity must come with clean hands, and he who seek equity must first of all do equity, because you cannot be asking for equity whereas you are not doing equity. Where equalities, equity are equal, the first in time prevails. So we have under the equity, we have injunction, we have ex parte injunction, we have interlocuting injunction, we have perpetual injunction, we have marital injunction, we have antopila injunction. That is to say, equity had a lot of remedies to render to litigants that were victimized and suffered under the hands of common law. That is why when equity came, it came to relieve the harshness of common law and ameliorate that harshness. Because when the equity came, people were now rushing to equity court. There was not crisis between common law and equity. So the common law court and court of equity continue to exist side by side with different jurisdictions and with no love lost with each other. Until the famous Hell of Oxford case, when the rivalry between the two courts got to breaking point and burst. So in the Hell of Oxford case, the plaintiff had built a house on the leased land and planted tree in the garden. So the defendant at the Hell of Oxford, who was the owner of the land, forcefully ejected him. So the plaintiff sued the defendant in the common law court for wrongful ejectment and lost. So the plaintiff thereby brought another action against the defendant, this time in the court of chancery, praying inter alia a common injunction against the defendant not to eject him from the house he built on the land. So the court of chancery made an order in favor of the plaintiff, restraining the defendant from ejecting him from the house, thereby frustrating the execution of the judgment of the common law court in favor of the defendant against the plaintiff. So Lord Coke, the chief judge of the common law court, petitioned the king that the chancery court was obstructing the rules of common law. So Lord Ellesmere, the Lord Chancellor of the Court of Chancery, wrote back that by the law of God,
Hello, man. Hello, welcome. Lost audio.
he that built a house, must live in it. Yet the defendant in this case would have the house garden and orchard within, did not build or plant. So the king summoned the two judges to appear before his Attorney General, Francis Bacon, a common enemy of Lord Coke, to resolve the matter. After listening to the two judges, the Attorney General heard that where there is conflict between common law and equity, the doctrine of equity shall prevail. So the decision of the Attorney General was approved by the king. So today, when there is conflict between equity and common law, the equity will prevail over the common law. That is to say, equity did not come to replace common law, but it only came to ameliorate, to mitigate, to reduce the harshness and injustice of common law that was being done to people under the common law, where people suffer the wrong to be without a remedy. Then the second source of Nigerian law is Nigerian legislation. No, first of all, under that common law, we still have the Statute of General Application. When you say Statute of General Application, there are laws that came into force on or before 1st January 1900. Any law that came into force 1st January, on or before 1st January 1900, they are referred to as law of Statute of General Application. Then we have the Nigerian legislation. The Nigerian legislation is the source of Nigerian law that we are all familiar with, that we know. The legislation refers to the positive act of enactment or law by any body or group that is authorized to make law in any society in accordance with the procedure for making such laws. So it depends, however, on whether the political arrangement is a democratic one or authoritarian. So Nigerian legislation consists of statute and subsidiary legislation. The statutes are law enacted by the legislative arm of government, while subsidiary legislations are merely laws or rules made by the executive arm of government. Nigerian legislation could include, number one, ordinance. Ordinance, they are the law made by the central legislative arm of government of Nigeria before 1st day of October 1954.
Hello, ma. Hello, ma.
Then-
Can I hear you again, ma? Hello? Hello, ma.
We have the act.
Hello, ma. We can't hear you. Network is bad.
Hello, ma. We can't hear you, sir. We can't hear you.
Hello?
Okay, ma. Okay, ma. Yes, we can hear you now.
Okay, so under the Nigerian legislation, I said we have the ordinance, we have the act. An act is a law made by the central government of Nigeria under the civilian regime. That is to say, by the federal government. So any law that is made under the President of Tinubu now is going to refer to an act, or acts are laws made under the legislative arm of government of Nigeria at the federal level. They have decree. Decree, they are laws made by the federal government of Nigeria under the military government. Like, for example, the Supreme Military Council as the central legislative arm of government during the General Goyi Singh, General Yakubu Gowon, we have General Muritala Mohammed and General Olusegun Obasanjo. They were all laws made under this military regime. They are referred to as decree. They hereby decree, they decree. They don't make an act, they don't make an edit, so they decree. They will have law. Law refers to the law made by the state government of Nigeria during the democracy. That is to say, any law made by Governor Beboluna is going to refer to as law. They will have edits. Edits, they are laws made by the military government of Nigeria at the state level. So they are referred to as edits. They will have a bylaw. As the name implies, they are the law made by the local government of Nigeria. So they are kind of part of a delegated legislation because it's not all laws that the local government have the power to make. So they can kind of subsidize from the higher authority, which can be the state, and so therefore. So they are laws made by the local government level. They will have a subsidiary legislation. When you say subsidiary legislation, they are the kind of law made by institutions and bodies established either by an act of parliament or a law of the state. So it also forms part of delegated legislation because the law is made by designated government officials in the exercise of the power given by statute or an enabling law. They will have a rules, regulation, and orders. So a rule is defined as an established and authoritative standard or principle or a general norm mandating or guiding conduct or action in a given type of situation. While a regulation is defined as the act or process of controlling by rule or restriction, and it defines an order as a command, direction, or instruction. Generally, they are laws made by the executive arm of government or administrative bodies in the exercise of the powers given by a statute or an enabling law. So the nexus of Nigeria law is customary law. I think we'll continue from there next week, which is customary law. Thank you. Continue from customary law. Sir?
Thank you.
Thank you, ma'am. Thank you.
Thank you.